Welcome to the Deep Dive. We take complex topics, legislation, dense reports, and boil them down to what you actually need to know. Today, we're tackling something really important if you buy or sell used items in South Africa. The Secondhand Goods Act, Act 6 of 2009, whether it's jewelry, a phone, scrap metal, even cars. This law touches a lot of transactions. Our goal is pretty straightforward. Make this complex act understandable, whether you're just curious, maybe a student, or even running a business affected by it.
Absolutely. And affected is the right word. This act, which came into effect fully around 2012, replaced a much older law from 1955. It's fundamentally about policing the trade. That sounds strong, but its core aim is crime prevention.
Crime prevention. How so specifically?
Well, the stated goals are clear. Regulate dealers and pawnbrokers, specifically to combat the trade in stolen goods, and, just as importantly, to push for higher ethical standards in the industry.
Okay, so let's define terms. Who exactly is a dealer under this act?
It's quite broad. It covers pretty much anyone whose business involves buying and selling used items. That definitely includes scrap metal dealers and pawnbrokers. They get specific mentions.
And what counts as secondhand goods? Is it everything used?
Not quite. It's defined as goods someone else has used before, not the original manufacturer. But there are important exclusions. The big ones are clothing that's completely out, and significantly, any single item valued at less than 100 Rand.
Ah, okay. So small, low-value stuff isn't caught up in this?
Right.
That makes sense. Avoids too much bureaucracy for minor sales.
Exactly. The focus is on items that are more likely to be stolen or have higher value. Schedule 1 of the Act lists the main categories, things like jewelry, motor vehicles, phones and communication gear, household or office equipment, and importantly, controlled metals.
Right, those controlled metals are often targeted in infrastructure theft, aren't they? So if you deal in any of those items, you're definitely covered by this act.
You are squarely under its provisions, yes.
Okay, so let's dig into the mechanics. What's the first hurdle for someone wanting to be a dealer?
Registration. It's absolutely foundational. Chapter 2, Section 2 is crystal clear. You cannot legally operate a business as a dealer unless you are registered with the National Commissioner of the South African Police Service, SAPS.
So you need police approval before you start trading. Is it just one registration per business?
No, and this is a key practical point. Section 3.2 requires you to register each and every premises where you conduct business. That includes not just your shopfront, but also any place where you store these secondhand goods.
Each premises.
Wow.
Well, so if you have multiple shops or warehouses, that's multiple applications.
Correct. The police want oversight of every physical location involved.
How long does this registration last? Is it a one-time thing?
No, it's valid for 5 years, according to Section 7.5. And you need to be proactive about renewal. Section 11 says you have to apply for renewal between 90 and 180 days before it expires. So there's continuous vetting, essentially.
Okay, 5 years. And I imagine getting that registration isn't automatic. This seems like where the ethical standards part really comes in. What can actually disqualify someone?
Yes. Section 14 lays out some very strict disqualifications. This is really where the Act tries to filter out potentially problematic operators. For instance, you're disqualified if you've been sentenced to prison without the option of a fine in the last 5 years for any crime involving dishonesty. Think fraud, theft, bribery, that sort of thing.
Okay, so a recent serious conviction for dishonesty is an absolute bar. What else?
Also, if you've been convicted twice under this Act, or the old 1955 Act, within the preceding 10 years, especially if the second conviction involved a fine over R1000, you're out, it targets repeat offenders within the trade itself.
That sends a strong message about compliance. Any other disqualifiers?
Yes. Being an unrehabilitated insolvent, being under 18, or not being a permanent resident in South Africa also disqualifies you.
So it's about financial stability, legal capacity, residency, and crucially, proven integrity regarding honesty and following these specific rules.
Precisely. And speaking of integrity and standards, there's another interesting mechanism. Accreditation, covered in Chapter 3.
Accreditation. How does that work alongside the mandatory police registration?
It allows for a degree of self-regulation. The National Commissioner can accredit dealers' associations, like industry bodies. But these associations have to meet high standards themselves, integrity, capacity, proper governance, things like that, as per Section 16.
And what can these accredited associations do?
According to Section 17, they can set minimum ethical standards for their members, they can inspect their members' businesses to ensure compliance, and they can advise the Commissioner on matters related to the Act. It sort of empowers the industry to help police itself under SAPS oversight.
Interesting. A sort of partnership model. Okay, so once a dealer is registered, what are the day-to-day rules to ensure accountability? If registration is the entry ticket, what's the daily logbook?
The daily logbook is exactly right. It's the register. Chapter 4, Section 21 mandates incredibly detailed record keeping for every single acquisition, every item bought or taken in pawn, and every single disposal. Every item sold, an entry must be made in a prescribed register.
Every single item. And when do those entries have to be made? Can they batch them at the end of the day?
Absolutely not. Section 21.7 is critical here. The entry must be made contemporaneously with the transaction. So right then and there, no delays.
Contemporaneously. That sounds like a major operational requirement, especially for busy shops. What details need to go into this register for each transaction?
It's quite comprehensive. For the person you're dealing with, seller or buyer, you need their full names, their physical address, a contact number, and their identity number. And importantly, you must record the method used to verify their identity. Did you see their original ID document, their passport? You have to note that
It
down.
says note it down. Or do you need proof?
This is the big one. Section 21.5 mandates that the dealer must obtain and keep a legible copy of that person's identity document or passport page showing their photo and details.
Wow, okay. So not just checking the ID, but photocopying or scanning it and keeping that copy. That's a significant administrative and data privacy responsibility.
It really is. And Section 21.6 states that these registers and the copies of the IDs must be kept for a minimum of 5 years from the date of the transaction.
5 years? That's a long time. Imagine the storage space needed for all those paper copies or the secure digital storage.
Yeah.
What about the goods themselves? What details are needed?
You need a full description of the item, any serial number or other distinguishing feature or mark, the purchase price paid or the disposal price received, and the exact date and time of the transaction.
So basically a complete traceable history for every regulated item that passes through the dealer's hands, linked to a verified identity kept for 5 years.
That's the goal. Total traceability to deter the movement of stolen goods.
Okay, beyond the intense paperwork, does the Act impose restrictions on the actual act of buying or selling?
Yes. Section 23 lays out some key restrictions aimed directly at preventing problematic transactions. There are 3 really big ones for dealers and pawnbrokers.
What's the first one?
You cannot acquire goods or accept goods in pawn from anyone under the age of 18. Section 23(1). That's an absolute prohibition.
Okay, protects minors. What's the second?
This one puts a heavy burden on the dealer. Section 23(1)(c) says the dealer must be convinced on reasonable grounds that the person selling or pawning the goods is actually the owner or title holder or has the legal authority to sell them.
Convinced on reasonable grounds? That sounds subjective, but I guess it means they can't just turn a blind eye if something seems suspicious. They need to ask questions, maybe ask for proof of ownership for certain items.
Exactly. It shifts the responsibility. If goods turn out to be stolen, the dealer might have to demonstrate what reasonable steps they took to verify ownership. I didn't ask, probably won't cut it.
Right. And the third major restriction?
It's the mandatory holding period. Section 23(1) mandates that a dealer cannot alter the form or appearance of acquired goods or deliver them to anyone, like sell them on, for 7 days after acquiring them. And Section 23(2) adds that pawned goods must be kept separate and identifiable during the 7-day period.
A 7-day freeze, essentially.
Right.
That gives police time to check recent theft reports against the dealer's acquisition register before the item disappears or is changed.
Of course, it's a crucial window for investigation.
But what if the dealer suspects something is wrong during the transaction itself, before they even buy the item?
Section 22 kicks in here. It imposes an immediate duty to report. If a dealer suspects, or importantly, reasonably should suspect, that the seller is giving false personal details,
Okay.
or that the goods being offered are stolen goods, or that goods offered for pawn are stolen,
Right.
or that the item's appearance has been deliberately altered to hide its identity, like scratching off a serial number, they must immediately report these suspicions and all the details to a police official.
Immediately report to the police. And can they still go ahead with the deal if they report it?
No. Section 22(3) explicitly states that if a dealer suspects tampering meant to conceal identity, they must not continue with the transaction.
So the obligation is, suspect bagel stop. That makes dealers frontline detectors in a way.
It absolutely does. The Act requires them to be proactive about identifying and reporting potential crime.
Now, you mentioned Schedule 1 lists specific types of goods. Does the Act have special rules for things that are particularly high risk or frequently stolen?
Yes, it does. There are dedicated chapters for certain categories. Chapter 6 deals with controlled metals.
Like copper, aluminium, the stuff often stolen from infrastructure projects.
Exactly. Those metals are listed in Schedule 2. If you deal in recycling these controlled metals, Section 25 requires you to get an additional registration specifically as a recycler on top of your normal dealer registration.
Extra scrutiny for metal recyclers. Any other specific rules there?
Oh yes, the big one is about burnt cable. Section 25(4)(b) basically says you cannot acquire or dispose of controlled metal cable where the protective cover has been burned off. Unless the seller gives a reasonable explanation for why it's burnt, maybe legitimate stripping, though that's often questionable, and the dealer reports the whole situation, including the explanation, to the police.
Ah, the burnt cable rule. Directly targeting the common method of stripping stolen cables. Makes sense. What about electronics, like phones?
Chapter 7 covers communication equipment. Specifically, Section 26 focuses on things like cell phones, anything wireless that uses a SIM card and has an IMEI number. For these items, the dealer must record not just the make and model, but also that unique IMEI number in their register.
The IMEI. That's like the phone's fingerprint, right?
Yep.
So even if the SIM is changed, the phone itself can be identified if stolen and reported.
Precisely. It makes tracking stolen devices much more feasible, even internationally.
And what about motor vehicles? Obviously high value and frequently stolen.
Chapter 5 deals with vehicles. Again, additional record keeping is required by Section 24. On top of the standard transaction details, dealers need the VIN.
Vehicle identification number.
Yes, the VIN. Also the chassis number, the engine number, the reading on the odometer, and interestingly, any microdot particulars.
Microdots, what are those?
They're tiny, often microscopic dots sprayed onto various parts of a vehicle, each containing the VIN or a unique code linked to the VIN. They're incredibly hard to remove completely, so even if parts are swapped, the microdots can still identify the original vehicle. Dealers need to record this information.
Wow, that's detailed. Anything else for vehicles?
Yes, the seller must provide proof of the vehicle's registration, or if applicable, its deregistration, and the dealer must keep copies of these documents, again, for 5 years.
So for cars, it's an even more rigorous paper trail required. Like we have all these rules, registration, records, restrictions. How is this actually enforced?
Yeah.
Who checks up on dealers?
Enforcement powers are primarily with the police, laid out in Chapter 8, and they have significant authority.
How does it work? Can they just show up anytime?
There's a distinction. Section 28 covers routine inspections. Police officials can enter any registered dealer's premises during business hours. They can demand to see the registration certificate, inspect the registers, examine the goods on hand, and demand explanations for any entries, or, crucially, for the absence of required entries. In fact, Section 28(4) mandates that the police must conduct at least one comprehensive inspection of every registered premises annually.
At least once a year, a full checkup. What if they suspect something more serious than just checking compliance?
Then they can escalate using warrant powers under Sections 29 and 30. If a magistrate or judge issues a warrant based on suspicion of a contravention, the police can enter and search premises, seize registers, documents, or goods that might be evidence, and they even have the power under Section 30 to seal off the premises for up to 7 days to prevent ongoing offenses or preserve evidence.
Seal the business shut for a week. That's a powerful tool.
It absolutely is. It highlights the seriousness with which non-compliance can be treated.
Which brings us to the penalties. If a dealer gets caught breaking these rules, what are the consequences? Are we talking fines or something more?
Oh, much more than just fines, potentially. Section 32 outlines the offenses, and Schedule 3 links specific contraventions to penalties. And the penalties are severe. For many of the core requirements we've discussed, failing to register, giving false info in the register, failing to keep records contemporaneously, violating the major restrictions like the 7-day hold or buying from minors, knowingly dealing in stolen goods, the maximum penalty is imprisonment for up to 10 years.
10 years. For things like failing to keep the register up to date properly.
Yes. The law equates sloppy or missing paperwork with potentially facilitating crime. It's taken that seriously.
That is a very strong deterrent. Are there other penalties besides prison time?
Yes. Section 32(3) allows courts to impose additional penalties. These can include ongoing fines for continuing offenses, cancellation of the dealer's registration, essentially shutting down their legal ability to trade, and ordering that the goods involved in the offense be forfeited to the state.
So you could lose your business, lose the goods, pay fines, and face significant jail time.
Correct. The potential consequences are designed to ensure compliance is seen as non-negotiable.
Okay, this deep dive really paints a picture. The Secondhand Goods Act of 2009 isn't just some minor regulation. It's a comprehensive system designed to fundamentally shift how the trade operates. It seems to place a significant burden on dealers' registration, meticulous record-keeping, verification duties, holding periods, all backed by serious criminal penalties. It's essentially forcing the trade itself to become a key part of crime prevention.
That's a very accurate summary. It creates this detailed paper trail, both physical and potentially digital, making it much harder for stolen goods to be laundered through legitimate channels. And the focus on integrity from the start with disqualifications, plus the potential for industry self-regulation through accredited associations, aims to build a more ethical marketplace overall.
Which leads us perfectly into our final provocative thought for you, our listeners, to consider. This act essentially deputizes dealers, legally requiring them to verify ownership, maintain exhaustive records, and proactively report suspicious activity, acting almost like an extension of law enforcement within the trade. Given the potentially severe penalties we've discussed, remember, up to 10 years for what might seem like administrative failures. What are the hidden costs? Think about the time, the staffing, the storage, the technology needed for this level of compliance. How much might these costs add to the price you pay for secondhand goods? And the big question, is that added cost ultimately justified by the potential reduction in theft and the trade of stolen property? Something to mull over.